Good evening, everyone. I think we're all here in terms of the members of the panel, and I think we have our coordinators, so I think we can begin. So, bienvenue à cette rencontre du comité de dérogation pour la Ville d'Ottawa. Welcome to this hearing of the Committee of Adjustment for the City of Ottawa. The Committee of Adjustment is a quasi-judicial tribunal appointed by City Council to make decisions on certain types of applications under the Planning Act. So my name is Anne Tremblay, and with me today, I'll be chairing this hearing, and with me today are four panel members. I have Ms. Kathleen Willis with us this evening, Mr. Scott Hindle, and Mr. Colin White. Just a bit of a note, Ms. Willis will be off camera on occasion. That doesn't mean that she's gone. It just means that she's off camera. She's listening to what's going on and will be part of the decision-making on our applications as we move forward. So please take note that tonight's hearing is being video conferenced and it is being live streamed on YouTube. If you would like to get either a copy of the agenda for tonight's meeting or a copy of the video, because it will be stored on the city's Committee of Adjustment webpage. If you have any trouble finding it, just reach out to committee staff for that. All right, I'd like to also welcome this evening our committee staff. So none of this happens without a lot of behind the scenes work. So we have this evening with us the Secretary Treasurer, Monsieur Michel Bellemare. We also have three coordinators who really make the magic work. We have Ms. Emily Byers. We have Ms. Maddie Harriman Fernandez and Ms. Mandy Nguyen. All right, thank you very much. Okay, so a couple of opening instructions. There's a lot of issues surrounding development, and this committee only deals with very narrow types of applications under the Planning Act. And so in our case, what's really very typical are their consent applications and minor variance, although on occasion we deal with permissions as well. So with that, then, you should also know that because of the narrowness of the jurisdiction of the committee, we really can't entertain any issues with regards to property maintenance, property values, pollution, or noise issues. Also, we treat every application as if no construction has occurred. So there's no point in raising any prosecution for illegal construction or any of that stuff, because we just deal with the application on the merits of the proposal. Also, we don't in any way entertain negative comments about anybody involved in these proceedings, whether it's the applicant or the owners or the residents or anyone. So please be respectful of everyone as you make your comments. So as part of the Statutory Declaration process, everyone is supposed to, or all applicants are supposed to, erect a sign on the property and then provide a statutory declaration, written. What used to traditionally happen was that was a written component. With the online hearings, that's been a little more challenging. And so what we have instead implemented is an ability, you can still do the hard copy if you'd like, but we've also implemented a solemn oath or declaration verbally that we can read out at the beginning of every application. So without it, of course, we can't proceed. If you won't swear or affirm to the sign posting, then we can't deal with your application. So that's the way it works. So with respect to quorum, if we lose, in this case, quorum, that means if we lose more than one panel member, we can proceed with three, but if we lose two, then what we try to do, and well, what we would do, because knock on wood, we have not had to do this since we began all of this almost 2 years ago. So if it happens that we can't reestablish connection with that panel member so that we can reestablish a quorum, then we will step down any applications that haven't been heard to the very next meeting of the committee. So in terms of the hearing process, so you saw the agenda at the beginning of the hearing. What we typically do is we try to deal with applications that have that are more straightforward, that are more minor perhaps than some of the other applications that are before us. So in that case, we're not going to be asking for a presentation. So typically we just open it up to the committee members to make sure that they can ask some questions if they needed added clarification about the application, and do know that we have a chance to look at these applications in depth before we actually even get here this evening. So we've had a chance to review them on our own. We've had a chance to review them together. And so we're essentially here now in the hearing context. So sometimes there are no questions for clarification, but sometimes there are. So you'll see both happen this evening. So in that case, once the questions are done by the committee, I will open it up to the public. We do keep a speakers list. If there's no one on the speakers list, then I'll open it up to anyone in the audience who might have an interest in the application. So that's sort of the fast track. There are times when we ask for a full presentation, and we do in fact have 2 applications that we're going to be requiring that for this evening. But then again, it's the same process. Later, we get the committee members to ask questions for clarification, and then we go into the public hearing. And then at the end of all that, we deliberate as panel members and make decisions. So kinds of decisions obviously are we can grant the application, we can deny the application, we can adjourn the application, which does happen on occasion where there's clearly the benefit to adjourn, even during discussion that we identify that we can in fact allow an application to be further adjourned or adjourned to allow for the collection of additional information or the resolution of some issues. So, and then the application can come back and we can deal with it on those revised merits, if you will. So we can also reserve, and when we reserve, it means not that we don't make a decision this evening. It just means that sometimes we get a lot of new evidence provided to us by members of the public or other stakeholders. And in those cases, we may decide to adjourn on that application just for the evening. And then we re-meet right following this overall hearing, and then we make a decision on that application. So one way or the other, the decision is made before we leave this evening. So then once all those decisions are done, there's in fact a written portion that outlines the reasoning for our decisions, and that's sent 10 days. So it's issued within 10 days of the hearing. And then there is a 20-day appeal period from there, where anyone who disagrees or wants to appeal the decision to the Ontario Land Tribunal, you can do that, and there is a fee to in fact appeal an application to the province. Just to be clear. Okay, so that's pretty much the way we're going to run things this evening. Don't worry if I'll help guide you if you can't remember all of that, because it is quite a bit of information. So with that, are there any declarations of conflict of interest from our members? Yes, Mr. White, go ahead, please.
Thank you, Madam Chair. I have to declare interest on item 1 on our agenda, Hydro One easement application. Mr. Price is the agent on that. I have done some work with Mr. Price recently, and in fact, I believe I might have done some preliminary work on this particular application. So I wish to declare interest on this application. If I could suggest, if the coordinator could simply, in the interest of being able to deal with that, it's a fairly simple application, I believe. In the interest of being able to deal with it quickly, if I could just ask if the coordinator could black me out of the meeting when that comes up on the agenda as the first item, and just invite me back as soon as the matter's decided.
So, Mr. White, in fact, the application is going to be heard a little bit later this evening because we are asking for a presentation on that one. So, so no worries. We're going to deal with some of our faster applications, and then we'll get to that one. And at that point, we might even be able to time it so you don't have to come back and join us, Mr. White. So we'll see if we can make that happen for you.
I leave it up to you. Thank you.
All right. Thank you so much. All right. We do not have, and I take it there's nobody else then on the panel with any declarations of conflict of interest on either tonight's agenda or the agendas of any other panel today? No? All right. We don't have any minutes to adopt this evening. So we're going to go to the one adjournment request that we do have, and that's for application number 7 at 1127 Avignon. So I am looking for Mr. I believe on that one, I'm looking for Mr. Balzuc.
Good evening, Madam
Good
Chair.
evening. Good evening, Mr. Bunsick. I take it, Mr. Bunsick, we did do the solemn oath the last time. Correct me if I'm wrong, but I do believe we've already done that for this application.
That's my understanding, Madam Chair. Yes.
All right. I'll just if I'm wrong, I'll get one of the coordinators to head me off at the pass here. But otherwise, I think we can talk about the adjournment request at this point. And Mr. Bunsick, just catch me up here. So this has been adjourned a number of times. What were the dates of adjournment? Can you just remind me?
Yes, Madam Chair. This is our third hearing. We had early January and then mid-February, and now we're back. So
Right,
sorry, I was just going to say the first hearing, it was adjourned because staff had some concerns with respect to an eventual site plan and the location of the driveway and the size of the building. So the application was amended and brought forth in mid-February. At that time, there was some, well, and we'll get into this in a moment, but some concerns over access to the rear yard and if that would be required through the subdivision agreement. So we were asked to investigate, and we did so, and we had some discussions with staff and the legal department, and now we're back. So I'm happy to get into that, but
all right. So go ahead, Mr. Bunsick. Please give us the reasons for the adjournment this time.
So essentially it comes down to if the committee is looking to require that easement for access to rear yard for what is currently an exterior townhouse would become an interior townhouse. These are street townhouses. It's my understanding that Mr. White and Ms. Willis last time expressed some concerns over the fact that the other houses on the street have access direct to the rear yard through their garages. Due to the way this townhouse was constructed, the garage is at the front of the house rather than separating the two. And so the only access to the rear yard of the newly created interior lot would be through the dwelling itself. And it was expressed that for new street townhouses and new subdivisions, that typically there is an easement provided for access to the rear yard. So we were asked to investigate, surely there's something in the subdivision agreement or the site plan agreement that would require this. So we did go back through the site plan agreement, the subdivision agreement. We did not find any requirement to provide that easement. There is no site plan agreement. This predates site plan. We are not aware of a requirement through the zoning bylaw. And so it seems that it's a standard condition that's imposed on new street townhouse development through the subdivision stage. So I suppose the crux of the issue is that if the committee would only be willing to approve this application with such an easement, then we would be required to adjourn today and submit an application for that easement, a secondary consent. If the committee feels differently than they did before and would not be looking for that easement, then I believe we could proceed. That's my understanding of the situation.
All right. Thank you, Mr. Bunsick. Any questions by the committee? Yes, Ms. Willis, go ahead, please.
Sorry, just a comment to Mr. Baldock. I may have been misunderstood with regard to the issue of the easements, and I didn't expect that there would be any requirement in the existing subdivision agreement for access easements because the subdivision was complete without the need for them by virtue of the double garage doors, one at the front and one at the back of every garage. So it wasn't my intention to have you look through the old subdivision agreement, but given that it's a new development, and the new policy that's gone on for years is with regard, requires access easements. And this is a new building that would prevent access, that it can't be taken, you can't divorce the two. I think the severance has to be subject to the easement, access easement is my opinion on it.
All right, thank you, Ms. Willis. Mr. White.
Madam Chair, if I could just add to that, I mean, effectively, we are the subdivision approval authority in this case, and we do have the authority to apply conditions as we see fit. This is a logical condition, as Ms. Willis has indicated, to provide access to that, which will now become an interior unit. So, essentially the subdivision approval authority here, I think it's entirely appropriate that we apply that requirement.
All right, Mr. Budzik.
Yeah, thank you. I suppose it's just a matter of procedure, but it was my understanding that the easement could not be applied as a condition to the approval of the severance, and therefore it would be required to submit a secondary consent application for that easement, which means that and what I'm hearing from the members of the committee is that they would like to see that in order to move towards approvals, then we would effectively need an adjournment. We could provide that application fairly quickly within the week, but we would still need an adjournment in order to have that application for easement accompany our existing consent applications.
All right, thank you, Mr. Budzik. Can I speak with Ms. Cully, please? Because just to echo a little bit what Mr. Budzik has said, it's very clear from your report, Ms. Cully, that you're suggesting that the requirement for an easement triggers a new application for that easement, correct?
Through you, Madam Chair, yes, that is correct.
All right. And was that something, did you get that advice from legal? I just want to make sure, like.
And so easements can only be approved by the Committee of Adjustment. This is something we discussed at the last hearing as well. So you could effectively condition to have an easement, but the application would then come before you once again. So our understanding is that you'd want to have a complete application.
I see. Okay, now I get it very well. All right, so means we're into another application. So there's a number of other issues. Oh, Mr. White, go ahead, please.
Madam Chair, I'm not entirely convinced that a new application is necessary in this case. We have the authority to require conditions, and obviously one of those conditions is going to be the provision of an access easement. I'm not, and maybe I need some legal advice here from a lawyer, but it would appear to me that we should be able to, if we acknowledge that right-of-way easement is required, and if we are reasonably comfortable with where it's going to be, I'm of the opinion that we should be able to require that easement to be granted and effectively issue consent for such an easement to be granted as part of the decision on the overall application, which.
So I think what I heard Ms. Cully say is that you can put it in as a condition, but in order to clear it, it takes an application to the committee.
I'm not entirely in agreement with the necessity for the additional application, but I mean, if there's legal advice that suggests otherwise, I'm prepared to yield to that legal advice.
We don't have that legal advice with us this evening. So we have staff's very clear comments suggesting that would be the right way to proceed. So unless we make the specific request that we get that information back, we get a legal opinion on that when the application comes back, and we certainly can do that. Okay. I just, Mr. Hindle, you look like you might want to say something.
No, I was just, I was in line, I think, with the direction of thinking of Mr. White. So I think in this case, because there is a consent application open, we could request as part of that the applicant provide a revised R plan that includes a part demonstrating the area for the easement and the wording of that. I think the issue in that case would just be confirming the language in that. So I think regardless, we would need an adjournment to allow us time to review the easement language to make sure it aligns with what we would require. But it would effectively just be an amendment to the existing consent application.
Well, so that's interesting. So we can, I think it's worth it, and I'm going to look to Mr. Belmar to add that to our list of things that we often like to get clarifications from the city. So maybe we can ensure that we get maybe a memo off to them and get clarification for that in the future. Because this just doesn't affect this application, it could affect other applications as well. So it's kind of just a general instructions from legal would be good to get, I think.
Will do, Madam Chair.
Okay. All right, Mr. Budzik, back to you, because I think what we're seeing is that there's a number of other issues that affects your application as well, right? So issues with regards to, having to, and Ms. Cully, you can correct me here, but the driveway, the placement of the driveway, the relationship of that driveway to an easement, and then there's an ESR required. We don't have the results of that yet, as I don't even know if that's been undertaken at this point. So these are all things that at least in my mind, I don't profess to speak for everyone else on the panel, but in my mind, there's a lot of information there that can affect the overall functionality of the site for the use that's proposed. And I'd kind of like to see all of the answers and how they all relate to each other before we move forward with considering this. Thoughts by anybody else on the committee? Because I guess the difference here, Mr. Bolduc, is whether or not we adjourn to a date or we adjourn sine die.
Understood, Madam Chair. I am prepared to speak to some of those issues, and I did have some concerns, recognizing that this is about the adjournment and not the conditions themselves. So I would be. I suppose it depends on the complexities of those answers, right? With respect to the driveway and some of those site plan concerns, the approach that Ms. Cully and I had figured out is that a site plan could be a condition of approval with a development agreement, because essentially it comes down to the lot width of the retained lot in relation to the existing driveway, and that when you change that lot line, all of a sudden your driveway is more than 50% of your frontage. So we would have to show on a site plan that we're removing a portion of the driveway with a landscape strip to fix those arrangements, and we're confident we can do it. We've mocked up a concept, but a formal site plan would be provided as a condition of approval. Some of the other conditions, some of the other discussions in the report include staff agreeing that the driveway should be on Jeanne d'Arc, whereas previously they were pushing for Avignon. There's still a discussion about the front door being on Jeanne d'Arc to provide some active frontage. We're comfortable with that. The only other item for discussion was potential contamination and the requirement for an ESA. We are strongly opposed to such a condition. We don't think it's appropriate for this site based on the lack of evidence that there's any initial contamination on this site. We recognize, sorry, I guess I'm going a little too far right now. I can back off.
All right. Okay. So, Mr. Budzik, then I want to hear from the other committee members about sort of the complexities of some of these issues and where we might go from here. Thoughts, Ms. Willis?
I think it's a bit of an unusual configuration in all kinds of ways. Configuration of the lot with the unit facing Jeanne d'Arc, yard requirements, the fact that it's a different form of housing than any of the others in the row it's attached to. But I kind of agree that I think the applicant needs to know that if we're requiring I've forgotten whether they're 1.5 or 1.4 meter access easement to the rear yard, whether you can actually accommodate that and get the house and the yard without further variances and everything if you're basically flipping the unit on its side. So I think it's probably an exercise, if you've sketched it out already, to show that it can work. I think we would need to at least see how it works before we can approve the easement when it does come forward.
I can speak to that. We've mocked it up internally. I won't claim to say that I've drafted a site plan because I don't work in design. But functionally, it makes sense. We would just ask for the easement to be located partially over a part of the proposed driveway. We don't see how it has to be a separate pathway with its own separate access. We think that's quite onerous, that if there was simply an agreement that a portion of the driveway can be used for access to that rear yard, for getting patio furniture in and out or whatever else is required, then we could work through the language of that easement. If the committee is more comfortable with us preparing a concept to show the function of that rear yard space with respect to parking, the easement, and the proposed dwelling, we would be prepared to provide that. But it's also a condition of approval.
Chair, just as a follow-up, I'd be much more comfortable seeing it. Just in the example you gave, Mr. Baldock, what that implies is that you cannot park your car in that portion of the driveway because it has to be unimpeded access at all times for the use of the end unit. So I don't know that that's an appropriate way to provide an access easement where there's a driveway that's being used by vehicles. That's just off the top of my head. So I think we'd need to look at that.
So let's go back to the adjournment. Let's go back, because there's a lot of discussion about the merits of the application at this point. So let's go back to the adjournment. I guess I want to pull based on a lot of information that we still need, the fact, and the reason I asked you to go through how many times have we adjourned this at this point. I'm never comfortable adjourning this many sequential times and expecting the public to keep showing up and keeping tabs on what that date would be. So I'm going to propose that we adjourn this application sine die. That way it will get recirculated and everybody will be advised of the new date. And at that point, we would be looking for all of this information to come forward to us. So I guess I'm looking for a show of hands from committee members, all those in favor of an adjournment sine die. All right. Okay. So for the record, that is unanimous at this point, but I'll be honest with you, I've got to go back to the, I skipped a point here. Should have gone out to the members of the public because I think we do have members of the public, but so at least we know, Mr. Baldock, you can see where we're going with this as a committee, but I am going to hear from the members that are with us this evening on the question of adjournment. I just want to be very clear with everyone. We're not talking about the application right now. We're just going to be addressing the adjournments in this case. So with that, on this application, we've got Mr. Summers, did you want to speak to the adjournment? Mr. Summers?
Yes, I would like to.
Go ahead, please.
Well, I understand the process of adjournment, but I think that what I was presenting would speak to the easement, which I'm very happy to hear is in the equation, but also some data that may help everybody sort of picture what we're really talking about.
Summers, we're not talking about the merits of the application at all at this point. We're just talking about an adjournment date. So we're suggesting, the committee has indicated a preference to adjourn sine die. Sine die means we're not picking a new date. It means that the applicant needs to go and resolve the remaining issues, create the additional information that we're looking for, and then a new notice will be circulated to everyone, again, within the same area from the original notice with a new date. But we don't know what that new date is right now. So Mr. Summers, have you got any comments on the adjournment?
Well, we'll see what the date is and I'll represent my material at that point in time.
All right, thank you, Mr. Summers. We also have Mr. Courrier. Mr. Courrier, c'est à vous.
Oui, bonjour. Vous m'entendez?
Oui, on vous entend.
Oui. Non, c'est l'adjournement, je n'ai aucun problème. C'est juste qu'il y avait un point qui n'a pas été discuté. Puis, si on le ramène à la prochaine réunion, ça va être remis encore. Alors, mon point, c'était où la neige du 11-27 à Billon va aller, à part de dans la rue. J'aimerais avoir...
OK, on parlera de l'application, puis le plan de site, puis toutes ces choses-là à la prochaine rencontre quand on va rapporter cette application. Fait que pour le moment, c'est vraiment juste parce que qu'est-ce qu'on propose? C'est un adjournement sine die qui veut dire que vous allez avoir un avis pour vous dire exactement à quelle date on va revenir avec l'information.
Pas de problème.
OK.
Merci.
OK, merci beaucoup. Is there anyone else in the audience who has wants to speak to the adjournment request? All right, I'm not seeing anybody. Mr. Bodzik, I see your hand is up. Go ahead, please.
Thanks, Madam Chair. Just one last comment. My client did ask me to raise this point. They've noticed people trespassing on the property to take pictures. We have security footage showing people accessing the property. I don't know for what purposes, but my understanding is that some neighbors have been going on the property, look around. There are tenants who live in this building, and we think it's inappropriate. So we would just ask at this time, if anyone's listening, please stop walking on the property. Thank you.
All right, Mr. Bodzik, you might want to follow up with notices and mailboxes, that kind of thing, just to remind people about that. I'm just suggesting that in case there are people here this evening that aren't tuned in. So
thank you, Madam Chair.
All right, so back to you then, members of the panel. I think I know where we're going, but all those in favor of the adjournment sine die. All right, so just for the record, it's unanimous. We are moving forward with that. So Mr. Bodzik, I think what you've heard from us is we want to see all the information come back. We want to see a site plan. We want to see feasibility. I think that's really what you're hearing from everyone based on some of the issues that are in staff's report, whether it's the driveway, the easement, the possible contamination, all of those things. We would like to see that information come back cohesively to demonstrate feasibility, and then we can deal with a complete application. I think complete information, it's complete application, but more complete information, I think. So thank you very much. And we'll wish you luck, and we'll see you again sometime shortly, I'm sure. Thank you.
Thank you, Madam
All
Chair.
right. So that is adjourned, sine die. The next application that we're going to deal with then is the actual hearing agenda that we have. So we've got application number 2 is the one that I want to start with, which is for 2008 Quincy Avenue. And I'm looking for, in terms of the agent, Mr. Alain.
Good evening, Madam Chair. My name is Scott Alain. I'm a planner at FOTEN. I'm pleased to give a presentation if requested. I noticed that you said earlier that's not always going to be the case. So just let me know and I'll be happy to accommodate.
All right, no presentation required, but I do need to read something to you. So
yeah, of course.
Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies, that it was there for the prescribed number of days prior to the hearing, and that it was legible and visible for the entirety of that time? Do you either swear or affirm that to be true?
Yes, I swear that to be true.
All right, thank you very much. So we have had a chance to look at the application. We know what's going on, but there may be some questions for clarification. Anyone on the panel? Mr. White, go ahead, please.
Thank you, Madam Chair. Just have a question about, it seems that the question of legal nonconformity here has come up not only in the notice, but also in the submission by the applicant, the planning rationale. Could I get some clarification on the actual status? There's some indication that there may be legal nonconforming status, and then there's also some suggestion in the planning report that hasn't been established. Could I get some comment on that?
Certainly, I'll be happy to provide some comments, and I think that the planner at the committee also will have some comments as well. So, essentially, the original pursuit of proceeding through the building permit process would have been that if it was a legally non-conforming group home, there would be no need for a variance because it's a continuance of the use and you can continue to proceed through the permit process. The current owner of the property, they purchased it as an operating group home in 2019. So although it was previously operating as a group home, we don't have the documentation to prove when that was established, and therefore we can't say legally non-conforming in terms of the formal status because we can't provide the evidence that it has been continuous use the entire time, even if that's our informal understanding. So just an apology for the confusion on that, and I'll leave it to the committee planner if they wanted to add more on that, but that's basically how we came to this.
All right, thank you, Mr. Renee. Mr. White, you have a question?
Yeah, Madam Chair, it's my understanding that legal nonconformity can be certified through a statutory declaration of some kind, and perhaps the planner can clarify that for me. Obviously, that hasn't been provided here.
Go ahead, Ms. Ramirez.
Thank you, Madam Chair. There is a process established through the city to recognize or to legally establish that something has legal non-conforming rights. No application was filed under that stream. And as the applicant has noted that if they had the ability to prove that it was legal non-conforming, we wouldn't be at the stage of requiring a minor variance, but we can't say definitively that it has legal non-conforming rights. It has the use. The owner did purchase the lands in 2019, and before that it was operating as a group home, but I can't say definitively that this application has legal non-conforming, or this property has legal non-conforming rights to a group home use.
Yes.
Am I correct though that that process of establishing legal nonconformity includes the ability to provide a statutory declaration?
Those statutory declarations can be a part of that submission to establish legal non-conforming rights. Also previous bylaw information, as well as previous building permit information can be submitted, and there's a process where staff review whether or not there's merit to the application.
So that opportunity, the applicant chose not to go through that process. That's why we're here. Is that correct?
Yeah, well, just a little file history on this. So the client had some lawyers look at the file and look at to kind of proceed down that route, basically because as you can imagine, it's a more streamlined and it's a more if possible would be a more ideal route for establishing these renovations. However, it was determined that with the requirements made through the legal non-conforming process, that it simply wasn't possible. And speaking to just my experience on different files where the requirement has been to prove it's legally non-conforming, it can be a difficult process to find all the paperwork, especially things like pre-digital paperwork and things like that, in order to truly prove that it satisfies the legal non-conforming title.
Thank you.
All right. Any other questions from panel members? Ms. Ramirez, don't go away. I have a question for you. Ms. Ramirez. So in this case, sorry, what would the date be that it would have to have been prior? Is it 1999? So in other words, the use would have to have been in place before 1999 in order to have that legal non-conforming status?
Through discussions with staff internally, 1993 was the date that was settled on because there was another group home within that distance area that was already established.
All right, okay, very good. And Mr. Alain, no idea whether or not it dates back to something like that or somehow happened. If you had to guess, does anybody have has it been 10 years, 15 years? I'm just trying to get a sense of.
Sorry, Madam Chair, are you asking how long the group home has been in operation?
Yeah, like, is it like, so has anybody got a sense that it could be 10 years at least, or 15 years at least, notwithstanding that we can't substantiate whether or not it actually meets the 1993 requirement for legal nonconforming status? Do we know if it's sort of in a decade or two or less than that, or?
We have Leslie Giesbrecht on the call, who works for Participation House. I don't know if she potentially might have a little bit more insight on the history.
Yeah, let's see
Thanks,
if
Scott.
Go
My
ahead.
apologies.
Please.
Yes, thanks, Scott. Unfortunately, we're not too sure when the alternate provider had started providing services within that home. Right now, I'm not really sure. I know that they were in for at least maybe about 5 or so years, but that's something definitely I would have to look back into our records and maybe connect with the other provider if that information is needed.
All right. Well, it's just trying to get some sense of just how, how much time that the use might have been in the neighborhood, just to give it context. That's all. Okay. Mr. White, I see you have your hand up.
Thank you, Madam Chair. Just a, it's kind of a picky comment, but I noticed we did get a letter of concern, a letter of objection from a neighbor who provided a photograph of the property, 2008. The address, sorry. Anyway, the photograph of the property, and it seems to disagree, or it's a different photograph than the one that is provided that purports to be the subject property in the planning rationale. And I'm wondering if which one is correct, because I don't believe that I double checked it on Google Earth myself, and I don't believe that the picture in the planning report is the correct property.
So if you'll excuse me, I'll pull up just this comment just to have it in front of me to see where it might look different. But I can say that the planning rationale shows the correct site. And on that note, okay, I have it here, perfect. And in fact, of course, through posting the sign on the property, I can substantiate that it is the same site. So
in figure 2,
yeah.
Oh,
in your report that bears no
right. Okay. No, that's incorrect. I'm not sure how that got in there. I can send you. I have the picture of the sign I posted. I regret that error. I apologize for that.
So, Mr. Knight, are we hearing that in fact figure 2 then is not a picture of the subject house?
Figure 2 is an incorrect picture. That's correct.
All righty then. Okay.
Madam Chair, I don't think that has bearing on the merits of the application.
The location plan in figure 1 is correct, though, I will say.
Yeah. Okay. All right. But keen observation, Mr. White. I found that. Okay. Any other questions for Mr. Alain before we go to? To the public. Okay, so I'm going to go out to the public. I don't have anybody on my speakers list, but is there anyone in the audience who would like to speak either for or against this application? Okay, I'm not seeing any hands. Anybody coming forward? So with that, committee members, I think we're ready to make a decision. All those in favor of the application? All right. For the record, the decision is unanimous. We're granting the application. So with that, Mr. I don't think there's any other business for us to discuss with you.
Yes.
All right, then good luck with the renovations.
Thank you very much. Have a good evening.
You too. Bye now. All right, so we're going to go to application 3 and 4. And that is for 1209 Algoma Road and 1650 Comstock. So we're looking for Mr. Tyler Yakachuk as the agent. That's what I've got down. Good evening.
Good evening, Madam Chair.
So I think before we get going on this, there's a few things that we need to do. Need to read to. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies, that it was there for the prescribed number of days prior to the hearing, and that it was clearly visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
I affirm that to be true.
I beg your pardon?
Sorry, I affirm that to be true.
Thank you very much. Okay. We also have a couple of housekeeping changes to your notice that we need to read into the record. So my understanding is that the legal description needs just a little tweaking. We're going to add the words part of lot 25 concession 2. Is that correct?
That's correct.
All right. Okay. And I think we're going to leave it at that in terms of making the changes on that legal description. And that's all I have from a housekeeping standpoint. We don't need a presentation from you, Mr. Yakchuk. So questions from the committee? Anything on this application? Both applications, consent and the minor variance. Yeah, it looked pretty straightforward, I think, to most of us. Okay, well, with that then, we will go to, I guess, the public. We don't have anybody on our speakers list. So is there anyone in the audience who would like to speak for or against either the consent or the minor variance application? All right, I'm not seeing anybody come forward then with that. Okay, it seems pretty straightforward. So let's just vote then, members of the committee, on the consent application. All those in favor? All right, again, for the record, the granting of the application is unanimous. And for the minor variance, all those in favor? Mr. White? Are you in favor? Yep, okay. All right, so again, for the record, the decision is unanimous. We are granting the application. Mr. Yakachuk, you know that we have two conditions: proof of independent services and joint use and maintenance agreement. Good with
Yes,
all
that's
that?
correct. Yep.
All right, well, in that case, I think we're done here this evening, so thank you.
Thank
And
you.
good luck.
Have a good night.
All right, bye now. All right, we're going to application number 5, and this is for 58 Heritage Street, and I'm looking for Mr. Robinson, I believe.
Hi, I'm here.
Yes, hello. All right, so I think we need to do a couple of things. Well, one thing at least, the oath or solemn declaration. So do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies, that it was there for the prescribed number of days prior to the hearing, and that it was clearly visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
I affirm that to be true.
All right, thank you very much. I don't see any housekeeping changes required to the notice. We also don't need a presentation, so I'm going to open it up to any questions by the committee on this. Mr. White.
Thank you, Madam Chair. Just a question. I noticed that there were a number of correspondence submitted in support of the application. However, I didn't see anything in the submission from the property owner at 60, which would be the abutting unit, abutting semi-detached unit. I wonder if Mr. Robinson could just advise what consultation took place there with the.
So sure, yeah, the owners were in consultation with all the neighbors. I believe over the last year prior to even the application. So they may have not written a letter, but to my knowledge, they're also in full support. My clients have told me that everybody, all the abutting neighbors and everybody in the area are in support of it.
All right, excellent.
Thank you.
Any other questions? All right, I'm not seeing any other questions. So, and I don't have anybody on the speakers list. So is there anyone in the audience who would like to speak either for or against this application? Okay, not seeing anybody come forward. So I think, again, fairly straightforward application. Members of the committee, think we're ready. All those in favor of the minor variance application? All right, so for the record, the application is granted and that's unanimous. So I believe that's it. Don't think we have any other business, Mr. Robinson. Thank you very much.
Thank you, Madam Chair and committee members.
All right, application number 6. This is for 2573 Traverse Drive. And the agent on the applicant, or the owner of the property, I think I'm looking for Mr. Hector Campagna. Mr. Campagna?
Yes, I'm here.
I see you're there. I see you there. So that's good. Good evening.
Good evening.
All right. So we do have a little piece of business before we get going on this. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies, that it was there for the prescribed number of days prior to the hearing, and that the sign was clearly visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
I affirm that to be true.
Perfect. Okay. No housekeeping changes required to your application, so that's good. No presentation required. So I'm opening it up to the committee members. Any questions for Mr. Companion on this application? No? All right. As I said, we do have a chance to look at these applications before we get here a couple of times. So we are familiar with it. Okay. In that case, I don't have anyone on my speakers list for presentation to the committee or comments to the committee. So is there anyone in the audience who would like to speak to the committee at this time? Here's your chance. You can just raise your hand and the coordinators will bring you in. All right, I'm not seeing anybody. So with that, then fairly straightforward. Committee members, all those in favor? All right, for the record, the application is granted and that's a unanimous decisions or votes by the committee members. So with that, Mr. Campagna, do you have any questions? Because I think.
No, pretty straightforward.
Okay, all right. Well, thank you and good luck with your project.
Thank you.
All right. Okay, we're going to go to number 8 is next. And it's for Frank Bender Street, 2253. And Mr. Budzik, you are back. Okay. And I just want to make sure. Yeah, okay. So I think we have to do the oath. I'm just making sure we haven't done that in the past, but I don't think we did. So, Mr. Budzik, do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies, that it was there for the prescribed number of days before the hearing, and that the sign was at all times visible and legible? Do you either swear that or affirm that to be true?
I do affirm that to be true.
Okay, perfect. No housekeeping changes required to the notice on any of this. Questions from the committee on this one? So, Mr. Bozo, just to remind me, the application came forward to us. We had a severance already on this property last year, right?
That's correct, Madam Chair.
Okay.
I do have a couple items for discussion, but I'll wait my turn.
Okay, we'll just see. All right, I'm not getting any questions from the panel members. So, all right, go ahead, Mr. Bunzik. Then before we go to the public, we'll discuss your comments if you'd like.
Thank you, Madam Chair. It was just 2 comments with respect to the conditions. So if you wanted to go ahead to the public first, that would be okay. Or do you want to have that condition discussion right now?
Yeah, no, let's talk about the conditions now. I'm just looking to see this is Frank Bender, right?
That's correct.
Okay. And these are the conditions. I just want to be sure, because normally they give us, yeah, okay, all right. For whatever reason, they're not showing up.
They're not
in my
numbered.
summary list. Okay, yeah, that's fine. So go ahead, Mr. Budzik.
Just a quick comment with respect to condition. I did email staff with respect to this earlier, but it was like 4:30, so I didn't expect a response. But number 3, actually, I'll start with number 6. That's the easiest one. That's with respect to the asphalt overlay. I just noticed that it references Breeze Hill Avenue, and I believe that's just a mistake. It should say Frank Bender.
All right, so I just need staff to confirm here. So which staff member worked on this? Was it you, Ms. Ramirez, or Ms. Cully?
This one was Miss Bauer.
Ah, Ms. Bauer. Sorry about that, Ms. Bauer. Okay, so Ms. Bauer, is that an error? Are you in agreement with that we need to change that to Frank Bender?
Yes, thank you for that question, Madam Chair. That is an error. It should reference Frank Bender Street.
All right. So you're right, Mr. Bolduc. That was an easy one.
Glad to catch it. And then the other question was about number 3 with respect to the accessory structure and the condition for demolition. There's actually 2 accessory structures on the property. One is a garage, a steel-sided garage that would be, my understanding, fully compliant with the zoning bylaw. And then there's an existing shed, a wooden shed, that is within a meter of the property line. I believe this condition is referencing the shed because I see no reason to require the demolition of the garage through a condition. But I would just like to confirm that.
All right, Ms. Bauer, back to you.
Thank you, Madam Chair. Yes, I have no concerns with retaining any accessory structure if it does comply with the zoning bylaw provisions.
All right, so sorry. So the shed does not comply and we're asking it to be demolished or it's in the way, but the garage is okay.
Yes, I'm not certain which structure that condition is referring to. I had been under the impression that the accessory structures were being demolished, but I have no concerns with retaining an accessory structure if it does comply with the zoning bylaw provisions.
Mr. Budzik, just need to get clarification on this. So,
yep, it's my understanding that like the intent is eventually to demolish the garage because it will need to come down for the development of the lot at a future date. But the owners, I've seen some value in retaining the garage during the demolition and, for storing equipment and materials. So if this doesn't have to come down and it complies with zoning, then we see no reason for it to be removed. Also, the wording of the condition for accessory structure, the fact that it says or relocated in conformity with the zoning bylaw, leads me to believe that they are referring to the shed, which may or may not be in non-compliant. So we just wanted to confirm that there was no issues with retaining the garage until such time as they're ready to proceed with the development of that, and understanding that this condition is with respect to the shed only.
okay, so Mr. Budzik, you understand that if we actually add the words shed, which makes some sense to do, it means in order to clear the condition, you have to do that within, I think, is it 2 years now? Maybe is it 2 years for clearing conditions now? So you're telling me that you don't think you're going to move forward with the development of the property within 2 years, so the garage is going to stay?
The intent at this time is just to sever the lot for future development. So I believe the garage we just want to keep the flexibility with respect to the garage on that lot. The shed will be demolished or relocated in conformity with the zoning bylaw. So we can meet that condition for the shed. We don't think that condition should apply to the garage if it's fully compliant, and there's no reason to remove it until such time as our client is ready to develop that particular property, because it doesn't straddle a property line in the way the house does. So it wouldn't need to come down in order to meet the conditions of the severance.
And it would be in full compliance with the zoning bylaw.
Correct. And then the owners could use it for storage of equipment or materials while they're completing site works. Yeah.
All right, so I've got a couple of hands up here. Mr. White first, and then we'll go to Ms. Ramirez.
Madam Chair, with respect to the question of zoning compliance with the accessory structure, whether it's the shed or the garage, I've always been informed, I've always understood that in order for an accessory structure to be compliant with the zoning bylaw, it has to be accessory to a main use on the building. And if you don't have a main dwelling, you don't have a main use.
Good point.
It's a technical issue, but I know that in the past that those types of situations where it's the desire to retain an accessory structure in the absence of a main structure, that special agreements are required in order to get, in order to have them legitimately comply with zoning. Perhaps staff can comment on that.
Yes, thank you, Mr. White. That's an interesting point. Ms. Ramirez.
Thank you, Madam Chair. I was going to also highlight that accessory structures are accessory to a principal use that is in compliance with zoning bylaw. So if the original building is demolished, then the accessory structure should be as well. There is a section of the bylaw that deals with temporary uses, building or structures during the construction. So if the garage is being retained just for during the construction period, Section 71 deals with that, but if it's to be retained in perpetuity when the initial dwelling has been demolished, that would be problematic.
All right, thank you. Back to you, Mr. White.
Yeah, thank you, Madam Chair. Yeah, I agree. I think if there is a building permit being taken out or taken out, then retention of the accessory structure will likely conform to the zoning, but otherwise it would not.
All right. Okay, if that's the case, then back to the condition. The condition then was, based on what I'm hearing, the condition then applies to all accessory structures on site, shed and garage. All right, okay. So I'm not familiar with that. How do you allow it to stay? So special agreement is what you talked about, Mr. White. So I'm trying to figure out if there's a way to fix this.
Madam Chair, I'm not sure if that, I mean, I recall something many years ago, but I'm not sure if that's valid today. Frankly, unless if a building permit were taken out for the new development on the lot in which the garage is located, then I think it's legitimately conforming with zoning. If there's no permit for a main structure being issued, then I would suggest that it's non-conforming with the zoning. And I think staff would just confirm that.
Yeah, okay. All right, I'm looking for ideas then. So in terms of amending this condition, because in my mind then it literally stays as is.
If I may, Madam Chair, I think what I'm understanding, and our client is just seeking that flexibility. So I think if there was 2 years to clear that condition, then the building could remain for 2 years. They could proceed with the demolition of the main house. And then if a building permit were taken out on this property for which the garage, I suppose that building permit could be taken out before the end of those 2 years, in which case the garage would then be compliant. And if the building permit was not taken, then the garage would require demolition in order to meet the condition of approval.
Yeah, I would agree. Yeah, okay. No, that actually did make sense to me in the way that you explained it, which means that the condition stands, and the intent would be then that chances are you're going to move forward with redevelopment within the 2 years framework in any event, and if you do that, then you're that is another way to clear the condition in a sense. Mm-hmm. So, all right. And so now it really looks like we need to add an S to accessory structures in the condition. Is what I'm noticing. So why don't we do that? And then we'll leave it at that. Now, is there any other conditions, Mr. Buzik, that you wanted to discuss?
No, Madam Chair. Thank you.
All right. Okay. So we have made an amendment to the asphalt overlay condition and a very minor one to the accessory structure. Okay. Any other comments or questions by the committee? No? All right. With that, then I think it's time to go to the public. I do not have anybody on my list, but if there's anyone out there who would like to speak to this application, either for or against, now's your chance. All right, I'm not seeing anybody come forward at all. So with that, then, members of the committee, just want to make sure that I'm, all those in favor of the consent application and the revisions to the conditions as discussed. All those in favor? All right, for the record, the application is granted and it's unanimous for the record. So thank you very much, Mr. Bozic. It's an interesting one, so we'll see where it goes.
Great. Thank you, members. Thank you, Madam Chair. Have a good night.
Good night. On to number 9, looking for, I think, Mr. Ireland from Novatech for 820 Grenon Avenue. You know Mr. Ireland? Yes, we do. Excellent.
Yes,
Good evening.
good evening.
Good evening. All right. So I think we need to read something to you. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted on the property to which the application applies, that it was there for the prescribed number of days prior to the hearing, and that it was clearly visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
To be true.
Sorry, I didn't catch that, Mr. Ireland.
I affirm that to be true.
Affirm it. Okay, thank you very much. Not seeing any changes to your note. Oh, yes, I am actually. There is a minor change to make. My understanding is that the applicant's name should read P. and R. Builders Limited, spelled out Limitted. Is that correct?
That is correct. Thank you.
All right, so we're making that change. Okay. Okay, members of the committee, any questions for Mr. Ireland on this application? No? Let me just have a look. Sometimes I have comments and questions. I have to just go back to my paperwork here. Okay, no, not seeing anything. It's an existing situation where we're creating individual lots. Mr. White?
Thank you, Madam Chair. Just a quick question. It appears that there was a building permit issued in 1966 for the original structure. Am I correct in assuming then that the bylaw that was in effect at the time, 1966, permitted multiple attached dwellings in this and on this location?
Yes, that is my understanding based on the planner's report. She looked at the bylaw and confirmed that, yes.
Could I get staff confirmation of that?
Yeah.
Yes, Madam Chair, the bylaw that was in place at the time was AZ 64, and it did permit row housing provided the lot was large enough and the lot does meet that frontage requirement. And so staff, did investigate the original bylaw and it was a permitted use. And then the owner has submitted an affidavit that the use has been continuous since that time.
Thank you.
All right, any other questions? All right, given that then, over to our list. Again, no one on my speakers list. So is there anyone in the audience who would like to speak either for or against this consent application? All right, I'm not seeing anybody come forward. So with that, Mr. Ireland, you're aware of all of the conditions of approval? No issues, okay, excellent.
No.
And the requirement by Hydro Ottawa for common element agreements?
Yes, we
Okay.
accept that. Yeah.
Excellent. In that case, members of the committee, all those in favor of this consent application? All right, for the record, the application is granted and it's a unanimous vote. All right, then, thank you very much, Mr. Ireland.
Thank you very much.
Good evening. All right, we're going to number 11, which is for 11 Tower Road, and we're looking for Mr. Segreto.
Good evening.
Good evening, Mr. Segreto. All right. I don't believe we read the the oath or the declaration last time, right? It was just went straight to an adjournment?
I think so.
All right, so do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies, that it was there for the prescribed number of days prior to the hearing, and that it was clearly visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
I swear that to be true.
All right, thank you, Mr. Segreto. With that, no changes to the application that I can see. Just, yeah, just catch us up. We had an adjournment for what reason, Mr. Segreto?
We had an adjournment because we were asking for a corner side yard setback of 3 meters, and there was an issue with one of the trees at the corner side yard. So what we did was we looked at it in great detail, and we had our arborist do some reports on it. If the tree would be, if we could save the tree at 3 meters, but since we got the report from the arborist, and with respect to the root system of the excavation of the property, whether it would be 3 meters away or the required 4.5 meters away, that the tree would still get damaged and it would have to go. Therefore, what we did was we revised our site plan and we indicated that the tree would be removed. And then we had a list of new trees that would be added to the plan. And the plan is in my presentation. We are adding, I believe it's 8 new trees on this site. In addition to that, there were 2 other trees of concern in the front, but those 2 trees in the front would be moved as well.
All right. Okay, thank you. I just, Ms. Young, just want to bring you forward just for a minute, just to get confirmation you've had a chance to look at this and you're in support of the proposed compensation, I guess, if you will, for the loss of those 3 trees. Is that correct? Or tree number 3, I guess.
Yes, it's for all 3 of the trees. I just want to make sure. Yes. So the required number of compensation trees is 8. And I believe the tree planting plan that's been submitted provides 8. So, I mean, while it's not ideal to remove all 3 of the trees on site, the applicant did undertake an exercise to look at what it would take to retain the tree. And it's thought that it would be quite difficult to do that with an additional building there. So I think the best solution here is to focus on what can be replanted. And I think they've done a good job of putting together a plan that will be acceptable for the community.
So remind me again. So when we have a consent application, because this is a fairly, I'm going to say a fairly complex kind of arrangement that we're making here. So we got 3 trees and we're replacing them and we're putting trees back front. So it's quite a bit going on here in order to essentially be able to ensure that we're compensating in some way. So on a consent application, we can ask for securities. There's all kinds of mechanisms for us to ensure that that actually happens in the fullness of time. Remind me again, on a minor variance where we have no conditions, there's no securities, how do we ensure that this actually happens and that those trees, somebody's verifying that they'll actually survive?
In this case, because the number of trees are being removed, they require permits from the city. There will be a condition through the tree permit to plant the required number of trees and to provide a planting plan, which has already been provided. But so the condition is tied to the tree permit in this case. So forestry staff will be following up on the planting of those trees and the survival of those trees.
There's no securities though, right, Ms. Young?
No, so it's less ideal than if we could do something through a consent here, but unfortunately this is not a consent application, so.
Thank you. Just bears reminding me sometimes because I'm not, I just want to make sure that if, this is a lot of goodwill, Mr. Segreto, so that's great. We're very happy to see this when this happens. It's just some, I'm just thinking about some of the neighbors who may be concerned about how this is actually going to be implemented. And so at least we have a good answer. So thank you, Ms. Young, for that. Mr. White?
Thank you, Madam Chair. So am I correct in understanding that the proposal will be removing 2 substantial coniferous trees at the front of the existing house and also the deciduous tree that's on the flanking lot line? Is that correct?
Yes, that is. It's the one on the corner, yes, on the side.
Plus what about the large coniferous trees that are on the front?
Yes, there are 3 trees that are being removed, 1 on the side, on the corner, and the 2 in the front.
Thank you, Madam Chair. Those are very significant mature trees that are being lost, just as a comment.
Yeah. Okay. All right. Thank you for that. It's good to see that. All right. Any other questions from Mr. Segreto or staff? All right. I do have some speakers for this application. I've got Ms. Nancy Wilson and Ms. Jill Prott. Good evening.
Hi. I guess I'll start off. Good evening, Madam Chair and committee members. City View Community Association, as always, has their comments to make for this hearing. We apologize for our late submission today because we've been in constant meetings. One of them was an OLT meeting that we've been preparing for and being ill too. So this is our best shot. There's a picture that I'd like to have put up if that's possible. We sent up, there we go. This is a picture of 11 Tower Road as it is now, and you can see those coniferous trees and the one in the back there. We'd just like to mention before we start that this is a shame that this perfectly good, well-maintained family home in excellent shape on a beautiful mature tree lot is to be demolished for the profit of the developers. This would have been affordable housing, not anymore. And then we'll move on to the OP. We would again like to remind the Committee of Adjustment, the planners, and the applicants that any provisions under the new OP will not be considered until such time as the required secondary plans and new zoning bylaws are enacted. For the 4 tests, the committee is authorized to grant a minor variance if all of the 4 tests are met. City View Community Association reviews each application along with the city planners report and the tree report to ensure that the information is complete and accurate and meets the zoning bylaws, and each infill is appropriately developed for our community in height and character. The addition of the corner side yard variance is not desirable for the appropriate development of this property. In this case, the variances are not minor and the general intent and purpose of the zoning bylaw are not being maintained. Corner yard setback. The City View Community Association objects to the requested variances for reduced corner yard setbacks. This is the side of the new build that faces the street and will allow this new build to extend further past the existing houses on most of St. Helens Place. By keeping the setback to the allowed 4.5 meters as required in the bylaw, this would better meet the streetscape and character of the neighborhood. This would have also protected and retained more trees and maybe the cedar hedge. City planners have made the same comments. However, in the newest report, the foresters have changed their mind. We consider that the other requested variances to allow for reduced frontage and reduced lot area are sufficient enough to allow for this infill development. Slight reduction in the building footprint would allow the side yard setback to meet and the bylaw to be respected. However, the developer must be commended for their work to make the side face of the building more compatible and aesthetically pleasing. We'd like to thank them for this. We have been in touch with them and they've been trying to make things better. The trees, it should be noted that trees cannot be planted in the city's right of way in City View because this is where our ditches for drainage exist. In fact, it is illegal to plant on the city's right of way anywhere in the city. This is why we work so hard to protect our mature tree canopy, as most of our trees are on our properties. We are unlike other communities with storm sewers and curbs and allow for tree-lined streets. The 5 proposed street trees are all in the right of way and are illegal. This is a statement from last night's ditch alteration policy meeting with the city staff, Brendan Denny's. So those 5 trees that they're replacing, of the 8 trees, are on the corner and the front in the city's right of way. As the planner notes, when lots become narrower and front yards become smaller, it's more challenging to maintain the street's character of landscaped yards and accommodate all of the uses typically included in the front yard. Further, the city and the Committee of Adjustment may refuse a development application where it deems the loss of trees is avoidable. Here are some examples of why we are so upset at how the tree bylaw is not protecting our trees. If you can put up the pictures, please. The first picture that you're going to see is at 50 St. Clair Avenue, which is just a few streets over. Nope, that's not the one. It's the next one. That one there, that great big, huge, beautiful tree. Well, today we got a phone call. And if you can go to the next picture, please. And this is where what it is now. So we're in touch with the city to see if there was a permit for that. We very much doubt it. That property was just bought by a developer, and this is how they prepare for Committee of Adjustment. So you can see how much that tree has changed things. Next slide, please. This is the kind of tree that's being approved as replacement trees following infill. We should all be ashamed that this is allowed to happen. $25 Home Depot tree or shrub. And that's what's been replacing those big, beautiful trees. So the infrastructure. City staff is well aware of the lack of storm sewers in City View and the importance of maintaining the integrity of the existing rural ditches for drainage. In last night's meeting with the City of Ottawa, it was again confirmed that ditches and culverts under driveways are a requirement of construction in City View. Conditions should be included to ensure that the existing drainage ditches on both Tower and St. Helens Place are retained and culverts are installed under the driveway. Also, the replacement trees cannot be planted here. And I'm going to let Jill take over from here. She's going to talk about the planning report. Jill? Is Jill there?
I can't see the gallery, so I can't.
Okay, well,
see her.
I didn't know I could unmute myself.
Okay.
Good evening, Chair and members. I wanted to talk about the planner's report. In the planner's report, it says the plan of subdivision for this area dates to 1913, and generally lots on this plan are 7.62 meters wide and 27 meters deep. At the time of subdivision, the service infrastructure necessary to accommodate a higher density had not been installed, so the area developed by including more than one lot, often 4 lots in one ownership. We'd like to remind the city that these 25-foot lots from 1913 were developed as garden lots, and they were never intended for development. In the 1950s, development started, and 4 lots were required to accommodate the septic tank, well, and the house. A higher density and its infrastructure were never contemplated here in City View. There's also a note in the planner's report that says the neighborhood is transitioning towards a denser lot fabric. We had a question for the planners. We want to know what's the difference between a neighborhood in transition and a neighborhood that is intensifying. The city planner notes under compatibility with existing contexts, staff notes there's a detached garage in the rear yard of 10 Tower Road that is set back approximately 1.5 meters from the corner lot line. The zoning requirement for an accessory structure is 1.2 meters, table 55, bracket 2B. The garage at 10 Tower Road is screened by vegetation along St. Helens Place. Our comments are, we like to know why we're discussing the side yard setback of 10 Tower Road, which doesn't align at all with 11 Tower Road at all. Also, on geomaps, there's no indication of garage at 10 Tower Road. You can see 10 on this map here, and the property we're talking about is number 11. The planning report says, under the heading of trees, the existing official plan 2003, subsection 245, has policies that supports a forest cover for the entire city of 30%. One way to accomplish this is to emphasize tree preservation and planting in the requirements for private development. The new official plan, 221, has a canopy target of 40%. We like to say that with this type of infill that we're seeing in City View and applications such as the ones that are being approved and the city's proposed new OP, these targets will never be obtained. The planners also said, under the heading of stormwater in City View, the city has undertaken a study of the City View ditch system to identify problem areas and come up with a phased remedial plan to improve drainage. Further, the city has been imposing ditch reinstatement through committee of adjustment and building permits. Planners, please fill us in. This is the first time we've heard of this. Also, we'd like to know, what is the committee of adjustments role with respect to the ditches? We've always maintained that these ditches are an integral part of these approvals. Under the heading of sanitaries in City View, the planning report says redevelopment reduces sanitary flows because owners are not allowed foundation drain or sump pump connections to the sanitary sewer, which is currently the case. Existing homes are connected to the sanitary system. A sump pump or foundation drain can increase the flow by a factor of 10 during wet weather events. By removing an existing foundation drain sump pump connection, the flow contribution to the sanitary system for that lot is greatly reduced, which compensates for any increase in domestic waste. We'd like to say that it's illegal for sump pumps to connect to sanitary sewers. But if that is the case here at this house, the community will have much more water flowing into its ditches for the detriment of the whole area and the drainage. This is not a good thing. We'd also like to add that there's no, add that again, because there's no severance here, City View community receives no cash in lieu of parkland because there's no severance. I'd just like to say we apologize for our late submission and thank you for considering our comments.
All right, thank you, Ms. Wilson, Ms. Pratt. Any questions for our speakers? All right. There are a number of things to explore, however, that were raised by both Ms. Wilson, Ms. Pratt. So, and I have just a couple of comments. So we did hear just recently, the Committee of Adjustment had a chance to meet with planning staff to talk about a number of initiatives that are underway. So there is an infrastructure master plan process, just so that you know, that's underway right now. I don't remember the timeframes, but they are intending to consult with all of the community associations. And does anybody remember what that date was? I want to say it's early 2023. Is I wrong about that? Something like that. So, yes, go ahead, Mr. White. I just want to make sure.
I think what we heard was that we're not going to see substantial work plan until a new council is in place. So that would put it at least setting the priorities not happening until sometime 2023.
I'm not talking about the secondary plans, Mr. White. I think there's already the infrastructure master plan initiative underway. So I think that one is, they had a timeline. So I'm going to ask committee staff if you could please provide the name of the speaker, and I don't remember the gentleman's name, who attended our meeting, who is responsible for that initiative. If we could at least make them allow for either Ms. Wilson or Ms. Pratt or both to chat with that individual, then maybe they can get the schedule and understand when they would have an opportunity to to in fact participate in that in the consultation process. So Mr. Belmar, can I count on you to do that, to have somebody from staff do that, please?
Yes, Madam Chair, we'll provide that information.
Okay, and yes, I think that would be enough. Okay. And that includes stormwater and the servicing. It'll give you an opportunity to certainly raise a lot of these directly with the people responsible for updating the infrastructure master plan for the city. On the trees, now that photograph was very compelling. It's one thing to see something on a plan. It's a different thing to see what the trees actually look like. And so I'm going to ask Ms. Young to come back. I'd like your opinion, Ms. Young, as to whether or not, so I know there's been some design changes, but the design changes haven't led in any way to the retention of these trees. In your, we've seen these comments from you before where you do have a chance to look at the site and analyze whether or not there's an opportunity to, in fact, maybe save one or two or another. So in your mind, do you think some further refinements would work in this case? Or I'm just trying to get your professional opinion on this as to whether or not, just how we might save one or two or all three of the trees.
Yeah, these are good questions. There is an issue on this site where there is an existing retaining wall built around the trees. So it's built on the opposite side of the tree from the existing house for those two front trees. So in the arborist's opinion, even if the house could be changed or something could be changed there to retain those trees, that the root zone is extremely limited by that wall. So she doesn't feel that those are retainable, the front trees, because of the wall. And on the other side, the one tree that's on St. Helens Place, that one is below the retaining wall. And that's one that I was really hoping to protect. And we've been really pushing to try to see what changes could be made to retain that tree. And the arborist came back, they did their study, and I can't read this on here, I think the setback of the building would need to be something like 6 meters from the property line they're saying, in order for the tree to be retained safely over the long term. So with that, I mean, it seems like it would be quite a loss of buildable area. I would still think that something could be done to design around it, but it would be a great departure from what has been done in the past. So I've been on the fence with this one, and I do think something could potentially be done, but it would take a lot of redesign. So I don't know if that helps.
Okay, so Ms. Young, that's exactly what I was looking for, because I do think that when we have that kind of tree, mature tree, and they're healthy, they're all healthy, we should do everything we can to protect those trees as part of development. So Mr. Segreto, I guess my question then would be to you, would be the extent to which you may have looked at different designs with I think we've heard from Ms. Young, the front trees are difficult to retain, but that tree on the side, in your mind, did you think, or did you look at different scenarios to be able to retain?
Yes, Madam Chair. Yes, we did look at it, and we did look at the fact that if we could do a more longer house in one of our earlier proposals, and it might be on our presentation. But the problem is that you'll have a building envelope. If you take 20 feet off that side, another 4 feet off the other side, the building will become so narrow, and it will be very difficult to do a decent building on that lot. It's just not going to happen. It's not going to happen. We tried, and I can assure you that we've sent in some of those designs. When you look at the root system of that tree number 3, which is on the side, you can clearly see that it's going through. If you're looking at the plan, you can clearly see that it's going through half of the house. So that tree will be lost, whether it's 3 meters away or 4.5 meters away, or even at 6 meters away. If you can go to my presentation and at least show that.
Mr. Segredo, I think we heard from Ms. Young that 6 meters would work, right? So that's what. So we have a standard. We have a measure.
6 meters will be very, very difficult to put a home on that property, and something that would be functionally working on that property.
So here's my thing. Like, I would prefer to be entertaining variances from the zoning bylaw if it achieves, whether it's height even in this case, if it achieves some of these other objectives. And so I think what I'm hearing from you is no matter what, like, so, and, you know, you've come before us before with proposals where there are minor variances because of the design, there's some minor variance. And are you telling me that you looked at all opportunities, including a design that might require a minor variance if in trying to retain 1 or 2 of these trees? Am I hearing that from you, that you looked at even at that?
We've looked at that, Madam Chair, and it's going to be very difficult. It's the situation of these trees and the root system, the way they hit the houses. It's going to be very difficult.
All right. Thank you, Mr. Segredo. Okay. Those are my questions. I think if there's nobody else, I'm going to continue with, because we did our speakers list, but is there anyone in the audience who would like to speak to this application? All right. I'm not seeing anybody else come forward. So, okay. So members of the committee, do we need to discuss anything at this point? And the reason I'm raising that is because I'm really not comfortable with the loss of all of those trees. I'm not sure I'm convinced that I've seen enough different possible scenarios that says, you know, no matter what, we're stuck. This is the only real way to proceed. Kind of where I'm at on this. Ms. Willis.
I too like trees. I can remember when we were being briefed at a committee of the whole meeting by staff about the new objectives and the stronger tree preservation guidelines that the city had, and they're actually the regulations that were better able to help us in the retention of trees. And at the same meeting, we heard about intensification and the objectives of the official plan and trying to make 60% of all, I think it was 60% of all growth within the existing neighborhoods. So I think in this case, it's sad to see those beautiful trees. It's maybe something can be done in future about ensuring that big trees are replaced with bigger trees than those which were shown in the slide by the community association. But I think that the applicant has spent a lot of time trying to make this work, and intensification and trees don't always, they're not always compatible, tree retention and intensification. So in this case, I think they've done their best and have come to an agreement with regard to replacement of those trees. And I think that this is not unlike a lot of other applications that we've supported.
All right, thank you, Ms. Willis, for that. Any other thoughts before we go to a vote? Yeah, Mr. White.
Yeah, Madam Chair, I'm sharing your concerns on what's happening in this community. If the lot infill sizes in this community had been maintained at the pre-2000 and roughly 2013 kind of standards, appropriate infill could and did in fact occur in the neighborhood, in the community, and that accommodated retention of a lot more trees. And in this case, this is another example of intensification that's gone a little too far in terms of the zoning bylaw that's currently in effect. It stands from when it was originally drafted in 1962. to me, it's a shame that we have to deal with this, and I've always can't understand why the standards that were in effect through the former city of Nepean, and then even later in with the newly amalgamated city, that the standards for infill in the neighborhood were a lot higher. I'm just still of the opinion that this is totally inconsistent with general purpose and intent of the bylaw provisions with respect to lot area and lot width. And I won't be supporting the application on that basis. It's not appropriate infill development under the current circumstances.
All right, thank you, Mr. White. Any other comments? Mr. Hindle, did you want to weigh in or ready for a vote?
Sure. Yeah, I would just, I think I would echo Ms. Willis's commentary. It's, it's a push and pull, and it's very, very much two competing objectives in this case. But in my professional opinion, I would put greater emphasis on the desirability of intensification overall, and with the, strong work that Ms. Young and Mr. Segreto and his foresters have put in, it seems like I think we're getting to as good of an outcome as we can in this situation, given the competing priorities.
All right, thank you, Mr. Handel. With that, then, group, I think we can go to a vote. So all those in favor? Yeah, so for the record, Mr. White and I are dissenting on this application. And I guess at the end of the day, it's not a dissent, because where there are 2 out of the 4 that are not in agreement, the application fails. So, and Mr. White, did you want to, I think you already sort of alluded to the reasons for your dissent, has to do with I'll leave it to you. Did you want to add to what you said?
No, Madam Chair, I think we've heard a number of times on applications in this community. It's not my opinion that the application is not minor, not desirable for the development of the subject lands, and it's not certainly not supportive of the general purpose and intent of the bylaw, particularly with respect to the provisions for lot area and lot width.
All right, thank you, Mr. White. My reasons are going back to the tree issue. It's not so much to do with the lot area or lot frontage. It's that I'm not convinced that that there is an inability to save at least one of those trees, and so I'm saying it's not in keeping with the general intent of the official plan as reported in by staff. Well, they didn't say it's not, but I'm talking about the sections. Go ahead, Ms. Willis.
Just a clarification, Madam Chair. In the case where the committee, a vote is lost, so it's turned down, wouldn't the dissenting people be Member Hindle and me, not you and?
Actually, you're quite right. You're quite right.
Huh.
At the end of the day, you're right. You're right. Because the decision's actually that it's denied.
Yes.
And so then it becomes those that you're quite right. Thank you very much, Ms. Willis, for raising that. So would you and Mr. Hindle like to give your reasons for your dissent against our decision, the decision at the end of the day? So no, take some time because it's important.
Well, I think I said mine in the little blurb that there is always a conflict between tree retention, enhanced tree retention techniques and requirements, and intensification. And I remember talking to this group about it being 2 steam trains coming running at each other, and there's going to be a collision at some point. So there is, as Mr. Hindle said, a lot of give and take. And I just think the applicant has gone a long way working with the offices of the city and Ms. Young, and they've come a long way to improve it. And it's just some win and some lose. So I think that this is very similar to many applications that we've approved in the area. And it's unfortunate that 2 or 3 mature trees have to go, but sometimes that happens.
All right, thank you, Ms. Willis. Mr. Handel, on the record.
I would echo the comments from Ms. Willis and what I'd said previously. I think those can stand on their own.
All right, thank you, Mr. Handel. So, Mr. Segreto, looks like the application is denied. I'm sure that you've been able to understand that. Okay.
I'm not very happy about it. Obviously, when there's a tie, I understand that. I understand these things, and there have been projects, as the other woman has just said, that have been approved, especially the ones on Withrow, where their bears did all those trees that he cut over there, and it's sad. It's just sad. I get it, but I don't think there's much that we can do about this, and it is what it is. Thank you.
All right, thank you. Don't go away though, Mr. Segreto, because I believe you're up next with the Ortona application. So, all right, with that, how about we do that? How about we move right to the next one, which is number 10 on 1634 Ortona Avenue. We do want a presentation on this one, Mr. Segreto, but before we go there, a couple of items of business. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted first at the property to which the application applies for the prescribed number of days before the hearing, and that it was clearly visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
I swear to be true.
All right, thank you. We also have a couple of housekeeping amendments to make to the notice, and I'll need you to confirm this. I'll read it. So we are, for clarification purposes, proposing improved wording, I think, is a way to put it, for amendment number A. So it's now going to read, to permit a front-facing garage to be 5.88 meters closer to the front lot line than the principal entrance to the dwelling, whereas the bylaw requires that the garage or carport not be more than 0.6 meters closer to the front lot line than the principal entrance to the dwelling. Are you in agreement with that?
Yes, I am. I am.
All right, thank you. And for B, we actually are going to signal a lesser relief from the bylaw. So to permit an increased driveway width of not 14.37, but rather 12.06. Are you in agreement with that?
Yes, I am.
All right. Okay, perfect. With that, over to you, Mr. Segreto, for the presentation.
Can we go? Yeah. Okay. So once again, this is the subject property, this two-story single-family dwelling. My client has owned it for a number of years. He would like to demolish it and build himself, his family, and his mother-in-law a coach house in the back and a brand new two-story single-family in front. The lot is approximately 100 feet wide by 200 and some odd feet in depth, 227 feet in depth. May I see the next photo? This is what we're proposing. The last time we talked about the driveway. It was the driveway that was basically the issue on this particular home. And I'll get to the site plan and then I can explain what's going on with the driveway and the changes that we've made. As you can clearly see, the driveway in front of the garage doors now has been shaded quite a bit, screened quite a bit. We put vegetation along the front. We also indicated new wall masonry lights on the side, so there can be no infriction with widening the driveway in any way on the right-hand side and on the left-hand side. Next slide, please. So this is the site plan, and the variances, as you said, Madam Chair. Variance A was the door getting closer, the garage being projected out further than the door, and then variance B is actually the one that you corrected, and it has been reduced to 12.06 meters. When you're looking at the red area, or the red area there, that's where the existing driveway was before, and it had a frontage of about, I think it was, let me see here, about 7.5 meters or so. So with the new driveway, which we reoriented it from the other plan that we did at the last hearing, we've reduced it to 6 meters. So it is less from the original one. And we've put the perma driveway along there and a little bit of interlocking on one side and on the other side. And you can see the way we've screened it now on both sides of the driveway. As you go further down, there is a driveway there as well, which leads to the back. I don't know if you can slide that up or not, or maybe to the next slide, you'll see the coach house in the back. Yeah, no, the next one, that was the proposal. Yeah, there you go. So you can see that the mother-in-law is hoping to move and live in the back, and she'd like to park her car in the back there. So that's the purpose of that driveway. There's no asphalt there at all. It's all the perambulated interlocking stone, which allows the grass to grow through it. Next slide. This is just an area showing other houses, similar houses, the subject property and other houses that have the driveways in front. Next slide, please. The lot fabric of that area. So you can clearly see that the intention of this is to show that the garage sticks out in front and the door is recessed in the back, and that the driveways are about 6 meters or so in width. Next slide.
So Mr. Segredo, can you tell us about what year though some of those were done? Because you know that the new policies could come in and then can't always use just the, what's in place if it's been there for a long time.
Yeah, well, these were probably built anywhere from 20, 15 years ago or so. Some of them maybe even recently, maybe 5 years or so ago. But you can clearly see that with respect to the lot fabric, it's no different. And we're going for 20 feet, a 20-foot wide driveway, which is permitted, which we're allowed. And this is just showing the neighborhood, the context of the neighborhood. Next slide, please. Again, you can clearly see that there's a new construction going on this one here at, I guess it's 1631. Next slide. These are a little bit older, as you can see. Driveways are even bigger in some of these. Next slide.
I don't think they've passed the test. Today's policies.
No, not today. The other thing too is Mr. White had asked if I could move the building back a little bit. I forgot to mention that. What we did do is we did move the building further back from the front lot line. We pushed it approximately 2 meters further back in order to accommodate a little bit more greenery that I think Mr. White was trying to get a hold of. But basically, that's the presentation, Madam Chair.
All right, thank you, Mr. Segredo. All right, questions? All right, I have go ahead, Mr. Handler, go ahead.
Sure, thank you, Mr. Segredo. And I do want to commend you. I think the changes that you've proposed have definitely addressed some of the issues or some of the concerns that were raised in the previous hearing. Now, I'm curious. I read the letter from the owner with intent, and she talked about how the intention is to fundamentally not park on the driveway, but she mentioned a total of 6 vehicles, and I only see 3 garage parking spots provided in the updated site plan. Can you talk about that discrepancy?
I can't speak for her. Maybe she's got a car, the husband's got a car, and she's got 3 or 4 kids. I really can't talk to that. So I guess they don't want to park in front, but in all fairness and honesty, there'll be always a couple of cars parked in front, as we all know. And I guess maybe 2 or 3 cars inside the garage. That's all I can say.
Fair enough. You're not the owner. Now, curious, as part of your, the work you did to look at alternatives, and I'm sure you did it originally when you were working on the building, why was an option to turn the garage and have it face sideways to reduce the width of the driveway? Why was that not ultimately ended up in the proposed option?
Number one, it was always difficult. Even if we slid the house over a little bit more, we could slide it over about another meter towards the north. But even with that in mind, with the hedges that are on that side that we're retaining, there's a bunch of hedges on that side that we didn't want to get rid of. And it was just not enough we need about 30 feet or so to back out. When you're turning in and you got to back out, you need about 30 feet, and we felt it was just a little bit too close to the other side yard. And the preference, in all honesty, was to have that look of the house with the garages in front.
Okay, thank you.
All right, Ms. Willis.
I was wondering if we could go back to the drawing that shows the rendering of the house. Was, I think, the first slide that you showed, Mr. Segreto.
Second. Yeah.
Second?
Yeah.
Okay, so I'm trying to make the rendering sort of match the site plan. So first of all, I'm wondering why, if the garage at the front of the house has only 2 parking spaces in it, why is it so big?
Well, I think you can park 3 cars in that garage. We just showed the 2 there. I think that's really a technical problem that we did. But you can see that the one door, it looks like it's a double door anyways for 2 cars there. And the other one is obviously for a single car. So you can put, 3 cars inside that garage.
So in fact, there's three spaces there. And similar, I was going to ask the same question at the coach home, why you've only got 1 space with that big wide driveway going in, but just 1 space. Why couldn't it be made smaller and the driveway may be made narrower? Or is it intended to be a 2-car garage?
I think that at the end of the day, you've got 24 feet there. So you could probably put 2 cars where the coach house is in the back. Yeah, you could do that.
So in fact, there are 5 cars that will be accommodated in the garages.
That's correct. You could put 5 cars, yes.
Well, so sort of answers my question as to why at the front, I was wondering why you wouldn't make the garage smaller, put the garage doors closer, but I can see from that drawing that it's actually a double car and a single car door. I also wanted to know at the front, you've put some more landscaping across the front. Again, with that, can we go back to the rendering again? Mm-hmm. Those low bushes don't look very like screening material to me. And I'm just wondering if you've had any discussion with a landscape architect or an arborist or somebody about is it intended that they stay so low if they're trying to screen parking?
Honestly, I think they were just drawn low, but you know what? I'm sure they could put a nice cedar hedge along that front there that's at least 4 feet high, just to screen all the front really nicely. I can make sure that recommend it to the owner and make sure that he can put something higher there.
So I'm not promoting a cedar hedge necessarily. I just thought that as screen planting goes, that does not look like it's a very effective screen, and leave it up to you to deal with that with the, I don't know.
I will mention it to the owners. I'll bring it to their attention.
Thank you.
Mr. Grota, just as a reminder, we do tie our approvals to plans, right? So the approval with all of the landscaping that you're proposing would actually be part of that approval, right? That's what we're saying.
Yeah, no problem. Yeah.
Madam Chair, there's no species shown though, and I don't know whether a cedar hedge would be a desirable screen or not. I'm not an expert in landscaping.
So let's go back to your site plan then, Mr. Segreto. Did you didn't specify anything as part of that site plan?
It doesn't look like anything was specified. It just shows plants along there, but we can get something there that we can specify something. I can send something in indicating what we're proposing to put there.
Well, just if we're tying it to plans, it would be nice to know exactly what it is that we're proposing, because you're selling this as one of the features that makes all of that paved area a little more, I guess, palatable, right? So if that's the case, then some detail about what we're actually going to be screening with is useful. I have just, if you don't mind, Ms. Willis, just to continue with your line of questioning. So you've got the driveway that goes to the back, but you've actually now are proposing that there's going to be that landscaping. So again, back to, we're tying things to plans. So is the intent, in other words, how would somebody go to the back of the coach house and access that, if there's cars parked directly in front of the garage, so how would that maneuver work?
Well, Madam Chair, the thing is that the car in the back is for the mother-in-law, the elderly woman, and I'm sure they can make arrangements talking to the daughter that, you know what I mean, if she's got to go out for groceries or to the doctor, you know what I mean?
What I'm worried about, Mr. Segreto, is that planting where we see the words light post and the light post, never going to happen. It's never going to happen because it's going to be too much of a constraint.
Not if you tie me to plans. I explain that to them and they will do it. If you tie us to plans, we'll put those lampposts there. And the whole idea of the lampposts is that you could not widen the entrance where the driveway is there. It's at 6 meters and that's it. So it can't get any wider.
Not getting a warm feeling about this, I'll tell you. Because what's that width then what's the distance then, Mr. Segreto, between the front of the garage and that, not the lamppost, but the actual beginning of the vegetation? How many meters have you got there? Just trying to see if I can see it on your plan.
I would say roughly, I would say at least 6 meters, 20 feet.
I don't think you got 6 meters.
Oh yeah. If you look at the width,
if you look from the front, really, because I'm just looking at the other measurement that you've got there, that's 2.99. And I would suggest.
If you.
Okay, maybe.
Yeah, you got 6 meters there. I can give you that number, Madam Chair, if you.
Yeah, I would like that number.
Actually, it would be a little bit more than 6 meters. If you look from the front of the garage door to the orange mark there, that is wider than the width of the entrance to the driveway, because the driveway width is 6 meters. I can give you
that's a parking space, right? That's a parking space, just a little bit better than a parking space, right?
Yeah.
So automatically, the minute there's a car parked in front of that garage, you're having to do the switching of the vehicles around, which really, to me, is that really then function well? Is that anyway? Okay. Any other questions from the committee on any of this? Mr. White, go ahead, please.
Thank you, Madam Chair. Just a question, staff here on the secondary plan that's cited in the report. The suggestion is that the Carlton Heights secondary plan has a policy that no new driveways or new private approaches are permitted, regardless of the number of lots or dwelling units resulting from development or redevelopment. Certainly, it's not particularly relevant to this application, but am I correct in assuming that if I build a new unit in Carlton Heights that has a driveway that is designed to have a driveway, that it would not get approved? And secondly, is this secondary plan a statutory component of the official plan? In other words, it's official plan policy as opposed to secondary planning policy applying to the community. But anyway, most importantly, what does this mean for driveways in the Carlton Heights area?
Through you, Madam Chair. The Carlton Heights secondary plan does speak to the fact that no new private approaches can be put onto the property. In the event that something is proposed, it is often a discussion with staff to see, I understand another application went before a different panel that used the same area of the driveway and reworked it in order to provide the same impact on the property, something similar to that effect. But this would be much larger than what currently existed, which is why it would not meet the intent of the official plan. And it is a secondary plan, not a community design plan. So it is under the official plan. Mr. White.
Mr. White, you are on mute. So if you could start again, please.
Again, if I'm building a new single-family residential unit in Carlton Heights, I'm tearing down my house. is building a new unit, I am not permitted to install a new driveway.
Through you, Madam Chair, that is what the policy states.
Sorry?
Through you, Madam Chair, that is what the policy states. Though I have seen the policy goes on to specify lots of things to do with the driveway, but essentially the intention is not to increase the effect on the stormwater in the area, because it was studied, from my understanding, and from that study it was found that there was a lot of stormwater drainage occurring because of the increased private approaches. So that was added into the secondary plan to avoid an increase to that stormwater that was running because of hard surfaces. That's my very general understanding of it. I'm sure an engineer could speak to that more fully, but that is what I understand the reasoning for that policy to be put in place. So as a result of that policy, there has been instances where they use the same area to use it so that the new development could occur and have it in a different place. So essentially the driveway is still the same. It's not taking up any more area, but in this case, it would be taking up more area, which is why it doesn't meet the intent of the official plan, in our opinion.
All right, thank you.
Thank you.
Any other, Ms. Willis, go ahead, please.
Madam Chair, I'm just wondering if we can figure out, I don't know why I'm really quite hung up on the, I like the idea of screening this amount of car space. And without the species being shown on the plan that we're considering, whether or not, if we do proceed with this approval, we can make it subject to the landscaping, subject to, I don't know if Ms. Young goes into this sort of territory with screen planting, or whether she's only trees, or if there's somebody on staff that could have the approval authority, so we don't have to bring it back, but still ensure that there's going to be adequate visual screening provided by these plants.
Ms. Young, can you come back? Okay. Is this something, well, if not you, who then at the city might look at something like this?
I could certainly review it and make sure that the species are appropriate. I don't have anything in mind right now to recommend, but if you wanted to put in a condition such that the species must be appropriate to provide adequate screening or something like that, then I could certainly review that when the plan comes in.
That would allay my concern about the screening.
All right, so that would have to happen pretty quickly, would it not? Like, so Mr. Segreto, pretty much before the decision goes out, would have to be able to provide that information and get that review done.
Madam Chair, I'm assuming another alternative would be to put a notation right on the site plan that the site plan we're looking at, saying that screen planting to the satisfaction of the City of Ottawa Forester. I don't know if that's your title, Ms. Young, I'm sorry, but urban forester.
So, okay, so let's just keep it more general. So Ms. Young, you are with PRED, I take it? Okay, yes, let's just make it more generous. I agree. I think that'll work if we do that. Just make it subject to satisfaction of, and then, is it the deputy manager of that department, and then they can delegate to whomever they want in order to make sure that they're happy with it. But yeah, I think we could do that actually. So Mr. Segreto, have any questions with regards to what we're asking for then?
I'm fine with that. I'm fine with that as long as Nancy is okay with it. I'm sure my clients will be fine with whatever she suggests.
Okay. All right.
Thank you.
Any other questions about this? No. Okay. I don't have any speakers. Oh, actually, I do have a speaker for this application. Ms. Holt, are you there? Ms. Katie
Madam Chair, Ms. Holt does not appear to be online.
All right, thank you very much then. Okay, with that then, is there anyone in the audience who would like to speak either for or against this application? Okay, nobody's come forward. So with that then, committee members, what say you? All those in favor? So 2 are in favor and 2 are not. So for the record, Mr. Hindle and I are both not in support of the application, and Mr. White and Ms. Willis are. So we're back to the same situation. So in this case, the application fails again, and we don't need to provide our reasoning, I guess. And it is in fact for you and Mr. White to provide your support, your reasons for support.
Okay, I think that with the revisions that have been made to the plan, they've gone a long way towards satisfying the concerns that were expressed by staff. And I think that with the change that was recommended regarding the screen planting at the front, that this plan is acceptable as is.
All right, thank you. Mr. White?
Thank you, Madam Chair. I agree with Ms. Willis' comments. His application is consistent with the general purpose intent of the official plan and the zoning bylaw and its appropriate development for the subject property.
All right, thank you, Mr. White. Okay, so Mr. Segreto, again, the application fails. I think you've heard some of the reasons through the discussion. So do you have any questions or any comments you'd like to make?
No comments.
All right, thank you, Mr. Segreto. And with that, then that completes our discussion on item number 10. So we're going to number 1 at this point, which means Mr. White, you can bid us farewell for the evening. So thank you, and we'll see you next time. All right, with that, looking for Mr. Price on 2469 Russell. Good evening. I'm going to need to read to you, Mr. Price. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted first at the property to which the application applies, that it was there for the prescribed number of days prior to the hearing, and that it was clearly visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
I swear, Madam Chair.
Okay. Couple of housekeeping changes to your legal description. So we're going to add, well, to 2 things actually. So we're going to add parts 4 and 5 on registered plan 5R 5597. Is that correct?
I'm just pulling up the plan here. Sorry, my Zoom skills. I've got part. Yes, that is correct.
All right. And on the zoning reference, we are going to leave it at O1P.
Yes.
Okay. All right.
Correct. Sure.
So is that just a quick presentation, Mr. Price, on what we're doing here this evening?
Sure, Madam Chair. For the record, Rod Price, for Land Development Consultants on behalf of Hydro One Networks, for the submission of a 14-meter wide right-of-way coming off of Hydro Road, swinging from the north, heading to just past an existing hydro tower and swinging east to provide access for the neighbor to the northeast. The purpose of the application, as some of you, I'm sure all of you recall, this area and various ownerships have been before you a number of times for a number of different applications. Through discussions with Hydro, the owners to the north, I guess call them northeast, and the rail line, it was thought that this would be a much safer access to the lands to the east. So you may recall there was a road widening that was extended where that cul-de-sac currently ends. And as you head to the 2 rail spurs that are there, it was getting very cumbersome in terms of how to cross those 2 rail lines. So Hydro One has made this application before you to allow their neighbors to safely cross those lines and gain access to the easterly property. I'm not sure if that helps paint the picture a little better or not.
All right. So no, thanks for that. I think that's kind of what we were looking for. Mr. Hindle, did you have any questions?
Yeah, so I was curious in this case. So is the intention that just because where the access easement would come in, you're still crossing a rail line, but you're crossing it so there's greater separation between the two rail lines, so it's easier to kind of make your way through?
That's exactly, through you, Madam Chair, that is exactly the case through discussions with the rail line. In order to achieve safe access, we were looking in, all kinds of signalization, bars going up and down, flashing lights. Whereas if they could swing a little bit more to the northeast, they can safely cross that rail spur with just an at-grade crossing. So we thought it'd be all involved prior to this submission, which, these discussions happened after the road agreement was entered into and whatnot. I think is a better outcome for everyone, much safer for all involved.
Okay, so in this case, we still have the legal access that's currently existing through Hydro Road. This is just an improved access effectively for safety reasons to fundamentally get to the same outcome, which is legal access to the property. But it's safer and easier for the rail operations, it sounds like.
Exactly.
Okay. That makes sense. I just wanted to make sure.
It's much cleaner than the other ones that have been before you previously.
Yes.
Yeah. And hopefully this is the end of it. This ties a little bow, I think, on most of these lands out there. So I hope, no offense, I hope I don't see you guys either in this area, and I see you in other files as well.
Yes, it's been a long road, Mr. Price.
And I appreciate your patience, but I think ultimately with all these chunks and parcels, we've come up with something that works for everyone.
All right, as well as.
Yes, thank you, Madam Chair. I'm just curious, what are the, I just don't remember, what are the plans for the hydro lands?
For the hydro lands?
Sorry, the Cohen and access to the Cohen and Cohen full line office, I guess, is the owner of the property?
Yeah, to be determined. The lands will be developed based on now having legal frontage, having access and whatnot. And they can take those lands to the market and begin to actually develop these properly in a safe and efficient manner under the guise of the official plan and zoning regulations that are in place. And whether that's themselves or somebody else in the future still remains to be seen. All these little exercises that I've been before you in the last year just to clean up this property to have what is, a parcel of land that's designated, for industrial use, so that, the owners can actually use it now.
So it's not really frontage on a public street issue because you have frontage on Hydro Road, right? It's actually vehicular access being permitted into the
correct
property.
That's right.
Okay.
Much safer access, yeah.
Okay, thank you.
All right. Okay, I think we understand the reason now for sort of this alternative to what was originally proposed, which I think was just to open up the rest of Hydro Road, I guess, and it has to do with that rail crossing. Okay. All right. I don't have any questions. And in terms of my speakers list, no one's on record. So is there anyone in the audience who would like to speak either for or against this application? All right, I'm not seeing anybody come forward. So with that, then, committee members, I think we can make a decision here. So all those in favor? All right, so for the record, the decision is it's granted and it's unanimous. So Mr. Price, good luck.
Thank you, Madam
All
Chair,
right.
members of the committee. I do appreciate your patience throughout this process. You guys have been wonderful. So thank you.
All right, thank you. And that takes us to the end of our agenda for this evening. So do I have a motion to adjourn? Ms. Willis, and seconded by Mr. Hindle. So that closes our meeting. As always, I'd like to thank our planners this evening and our forester, Ms. Young, for being here and always helping us